Good morning, everybody. This is Brad Rustin. I'd like to welcome all of you to our continued series in the trenches dealing with both commercial and consumer operational compliance obligations in the wake of the COVID-19 crisis. For those of you who are new to participation in our series, we'll have approximately 50 minutes of presentation. At any time, you can feel free to send questions in to the presenters over the interface inside of GoToWebinar. We'll try to address those as they come up, but we certainly also invite you at the end to ask any questions you may have on this topic or any others that you're currently facing, and we'll be happy to respond to those. We continue today with a commercial topic, specifically looking at special assets and default management. And your normal crew is joined today by Lee Hart in our Atlanta office. Lee is a partner there who focuses on complex workouts for lenders and financial institutions. He litigates in both bankruptcy and trial courts, and a lot of his experience has focused on complex real estate finance. So we're welcoming him today to present on some of these topics. And then you also hear from John Willis, who you may have heard previously in some of our prior webinars. He is former in-house counsel with two different banks inside of the state of Georgia. He's now working with us on our financial corporate and regulatory team, so we'd like to welcome him back. And then, of course, as usual, you have me and Craig Nazzaro, former in-house counsel, who is now part of the financial regulatory team at Nelson Mullins. And so we'll be the folks walking you through this today. In terms of where we're going today, this presentation is really designed to look at both lenders and debtors, but to understand some of the compliance obligations as well as ways to think about from both a risk and a business management standpoint of dealing with potential defaults, how you guard against those defaults, how you help borrowers work their way out of those defaults, but then if the need arises, what you should do in terms of responding to default and your post-default strategy and how you articulate this. A lot of what you're going to hear today are lessons that all of us have learned from the recession in 07 and 08, and some of the issues that we saw come up and that faced some of our clients as they worked their way through what at that point amounted to a fairly unprecedented number of defaults. In terms of where we think things are going, that we continue to track this. This is a relative tracking of default rates of the major lines of loans within a financial institution and comparing them to unemployment. As you'll see, they tend to track together, although not exactly a one-to-one relationship. But if you look at the commercial track, you'll see it tends to spike with spikes in unemployment and then lower. And so if we look at what potentially that impact could have as we move into the April 1st numbers, which have yet to be released, and May 1st, you potentially could have default projections getting close to 10% or just exceeding 10%. Given some of the intervention programs, we expect those numbers to be slightly lower as we get the April numbers in from financial institutions. But nonetheless, we should be seeing a spike in the number of defaults on commercial lines of credit or commercial loans that various financial institutions and lenders have made. And so the whole purpose today is to make sure we're thinking about it in a global way and thinking about how we're going to respond and adapt to the challenges presented by that. And so now I'll turn it over to my colleagues who are going to kind of walk us through how we think about default and how we go about addressing it. So Craig, do you want to lead us off here?
Yes, thank you. So, sorry, I keep on cutting in and out. The impact of default. When considering how default mitigation and special assets management impacts your institution, it can have impacts across various aspects of the portfolio. The principal advance could suffer a loss, the interest in non-accrual, employee monitoring costs, your FTE allocation, your capacity, all incur costs when default rates rise and default servicing becomes more of an issue. The administrative costs for special assets, your legal costs are going to go up, the use and leverage of outside counsel, various consultants to come in. Your reputational costs, depending on what kind of assets you have in the portfolio, you may want to give different deferrals to particular individuals and consumers that you may not want to be seen foreclosing on, and regulatory costs Are you managing the safety and soundness functions for the bank? Are you complying with all applicable regulations, specifically COA and CRA in these instances? Next slide, Brad.
Well, and Craig, one, I think, point you made that I think is good for our audience to hear is, as you think about the costs of default and, whether you're going to try to work through these defaults or conversely, take action on them, that there's a lot of significant expenses in terms of managing defaults. And as you think globally about what your best course of action is for your lender or institution, you need to make sure you're taking all those into account.
And you know what? That's a good point, Brad. And further to that point, you may be looking at outsourcing of the servicing of non-performing portfolios here in this case, and you're going to want to look at that, what the regulatory costs there are, the reputational costs for the outserving versus the cost saved in your operational expenses. It's something to balance when you're looking at how you're going to manage the increasing defaults within your portfolio. Next slide. So those of you that have been attending this webinar series have heard us talk about the importance around reviewing your policies and procedures associated with operational processes that may have not been a focus when portfolios were performing strongly. This advice very much applies to default management, including the processes that are listed here, like loan monitoring, loan default, cures, TDRs, independent oversight and controls, and various checklists and templates that might be deployed. All of these should be reviewed and analyzed for opportunities to remediate processes and process gaps in anticipation of your default rates rising dramatically in the coming months. Specifically, we are calling out the possible fair lending violations here. If your processes are not clearly defined, it will be hard to defend against allegation of disparate impact and pattern and practice violations when statistical disparities start to arise. Next slide, Brad.
Hey, Craig, on the procedures, one additional thought, with regard to monitoring is, I'd recommend it's probably important to be proactive with your internal and external loan review teams, and you may need to consider amending loan review schedules to make sure that the higher risk portfolios, as it relates to the impact of COVID, are getting a good independent credit review in a timely basis, and then that's being reported up the chain.
Great point. So monitoring credit accounts. So here I want to touch upon enterprise risk management functions and control functions should also be reviewed, and your methodology used within these functions updated. During your next exam, you're going to want to showcase that what efforts and what resources were being deployed to control the changing default environment. Were you monitoring for past due payments? Did you increase that monitoring? Did you look at communications with other employees to see what was going on within the origination channels and the servicing channels? Were you monitoring personal accounts, borrower financial performance? Were you updating or increasing these reviews? Collateral reports and valuation, field examinations, borrower visits. Are you monitoring for industry risks across not only your own portfolio, but within the industry spaces as a whole? And what were you collecting as quantifiable indicators? Were you looking at revenue targets, other default rates, collateral values, the sale velocity when REOs are taken in, the account agings? All have to be reflected in your controls and what you're reporting up. And you should be able to showcase that your FTE allocations for these monitoring activities increased as you realized the defaults were rising within the portfolio. Next slide, Brad, unless anyone has anything to add. Warning signs. It's important that you're tracking and escalating any and all warning signs that your portfolio is beginning to show signs of increasing defaults. You want to make sure that these warning signs are reflected in not only strategic KRIs and being escalated to executive management and the board, as well as operational KRIs and being escalated to managers, operational process owners, and department heads. You want to make sure that senior management and decision makers have all the up-to-date information to make any strategic decisions regarding loss allocation, accounting, material disclosures. So the warning signs you may be looking for these KRIs or escalations are sudden drop in earnings and revenue, increase in accounts receivable, sudden concentration of large accounts and receivables, sudden access to credit lines, a lot of drawing down, increase in inventory or collateral, questionable evaluations with the borrower submitting various documentation, calls regarding activities permitted under the loan documents, your complaint volume, can I pay later, any kind of inquiries that are around defaults or questions or complaints regarding forbearance processes or restructuring processes, a lack of communication with borrowers, billings going out, no one can find the consumers, the borrowers, or the entities. And management's overall response to the default crisis should be documented and formalized.
You know, one thing we saw there, Craig, as well during the last recession is that suddenly, you know, you would see these occurring maybe, 14 to 30 days before you had a sudden default, meaning, suddenly there's a lot of activity with a particular borrower, or conversely, no one can get a hold of, and contact a particular borrower. Bankers are reaching out to those individuals. They're not being responsive. They're passing you person to person within an organization. Maybe they haven't defaulted yet, but all of those should be kind of used to say, okay, this may be a sign of something that's to come. And, obviously, the underlying message you'll hear today is that the sooner you can intervene and work with those borrowers, the more flexibility you have as an institution or a lender. And at the same time, the higher the likelihood that you're able to craft responses for those particular borrowers. I mean, certainly when we dealt with the 07-08 period, there was a lot of times where there was not that contact, that communication. And by the time the bank realized that items had defaulted or you had gotten past the point of no return, in essence, and there was no way to come up with an effective strategy to keep liquidity, keep those assets moving, and keep those loans current.
Totally agree. I think the next slide is we're switching over to John.
Yeah, thanks, Craig. So when the lender determines that there is, in fact, a credit issue and a problem loan that's going to need some action, it's important to address and assess the credit file and take some immediate action items at the outset, with regard to the strategy. These are some action items that I think it's easy to postpone or procrastinate, but as Brad had mentioned before, the earlier you get to these things, generally the better position you're going to be in when it comes to your actual workout and your strategy. So, whether the credit file stays with the banker or relationship manager or shifts to a special asset department, the lender will want to have a good process and clear steps, of immediate action to take with regard to the loan. This slide provides some suggestions for those immediate action items. I won't go into detail on each of the items that are mentioned, but do want to speak to a few specifically with regard to your loan documentation and your workout file. I'll speak to this again a little bit more later, but again, it's good to have a clear process for what information needs to be gathered at the outset, where that information is going to be retained. I've heard this referred to as your single version of the truth, where all the documents are easily accessible, and your file contains all the necessary documentation you need to assess the loan and to take action. With regard to loan documentation, absolutely encourage doing a careful review and analysis of the core loan documentation to make sure all the documents are in the file, that they're accurate. Again, that early, Brad, if we could go back to the last slide real quick, I'm going to speak to it a little bit more on that slide as well. But again, just to make sure that you're looking at collateral and documentation from a valuation and perfection standpoint, the earlier you realize you may have some issues with your documentation, the better. As it's mentioned with regard to communicate, I agree. It's always good to have open and honest discussions with a client regarding the loan and the strategy. But be careful with your communications. Try not to overpromise, as oral and written communications can come back up as you work through your workout strategy. So, Brad, with that, you can go to the next slide unless anybody has anything else to add. Spoke on this a little bit before, but to be a little bit more specific, these are some of the specific questions that a lender can consider, both internal questions to ask itself when it's assessing its file, and then those questions to perform a legal analysis on, either with in-house counsel or outside of counsel. Again, looking at these questions, addressing these questions at the outset is of utmost importance. The quicker issues are discovered, the easier they are to address and hopefully remediate and fix. Sometimes you may think that you have a clear path to your resolution strategy, but in getting into the file, you figure out that there's an issue either with collateral perfection or a document is missing. And again, it's good to know that what issues exist at the outset. With regard to the internal questions specifically, I always like checklists. I think it's good to maybe take the questions, some of these questions, create a checklist that you can put at the beginning of your file to note which documents are in the file, and also provide any notes with regard to those documents. So get a well-organized loan file is obviously recommended. Specifically with regard to the legal analysis and some of the questions that are mentioned, again, be sure to coordinate with either internal or external counsel as you're going through your file and see any issues. Many of these questions are state law specific, so make sure you analyze the file and the collateral based on, for example, with real property, the state that the real property is in. Certain states have reversion and other lien issues that can prime a mortgage or invalidate your security deed or mortgage. So make sure that you are mindful of those laws and that you're looking for those pitfalls as you go through your loan file. Also, there's one bullet here that I think is important to mention. It says, has cross-default mechanisms been enforced? Oftentimes, your loan documents will contain cross-default provisions. Your account agreements may contain rights of offset, and it's important to know that those exist and not look over those remedies as a potential part of your workout strategy.
And John, I thought you made a good point yesterday as well, which is, the time when you can potentially address some of these concerns is early on in the process, when you're still trying to work cooperatively with borrowers and you're trying to address these issues proactively. If it's something where you're 6 months into a foreclosure or 6 months into a collections action, you may be stuck with some of these things.
Absolutely. And that's a bad surprise to have at that point in time. Better to go ahead and do the assessment up front to know exactly where things stand with regard to the loan file. You can go to the next slide, Brad. This is, to some extent, very similar to the prior discussion from the prior slide. It's important to have your well-organized single version of the truth, if you will, for your loan file. This will probably prevent stress if you have the analysis done on the front end, and certainly save time and can help avoid any confusion. As the slide indicates, having a good, well-organized file is going to help you make a more efficient and well-informed decision with regard to your workout strategy. This slide contains a list of the documentation and the things you would want to consider for your loan workout file. And again, I'm a fan of checklists and making sure that all of the files, to a large extent, are organized in a very similar fashion. This could be helpful if your strategy involves a single or a pool of loan sales. Often, most every time when you're conducting a loan sale, the purchaser at the loan sale is going to need assignments of security instruments, are going to want copies of all of the documents in the loan file, and to be able to gather that and get it to the purchaser in a efficient fashion will certainly save cost and energy. As the last part of the slide speaks to, I also think that having a well-organized workout file is very important for your external and internal auditor and regulatory exams. Being able to point directly to information that is requested and pull that information quickly in a consistent manner, it signifies, it's a good sign that the lender has good processes and procedures in place in dealing with the problem loans, that they're paying attention to the problem loans and their loan file. It's always better to, when an examiner is in the bank, to be able to get them the documents that they need in a very quick fashion, as opposed to having to run around and try to find the documents on a one-off basis. So that's it for me on this slide, Brad, Craig, Lee, unless y'all have anything else to offer.
Not for me.
So, talking about some of the default prevention strategies, before turning it over to Lee, mention some of the recent guidance that has come out with regard to pre-default loan modifications related to COVID-19. This was an interagency statement that was put out not long ago, and hopefully it's a good sign that examiners are going to be very mindful time. The guidance does note that that the examiners are not going to automatically adversely risk rate credits affected by COVID-19, including those that could potentially even qualify as a troubled debt restructure. I know that many lenders have instituted payment deferral and modification programs, and that this statement does definitely indicate that lenders are not going to be criticized for doing so. As a matter of fact, it indicates that the regulators see that as a prudent practice and encourage it. Again, it's good to be, and the guidance indicates that it's good to be proactive, be prudent, make decisions in a safe and sound manner in order to mitigate risk. And with that, of course, we would encourage lenders to have a written policy program related to their payment deferment programs that they may want to put into place.
Yeah. The only thing I'd like to add to that, John, when you're mentioning the joint statements on TDRs and not having to put them in that category immediately, I do think it would be a good practice to kind of quantify what you're tracking in that population of loans, those that would normally be classified as TDRs but may not be under the recent guidance, just so you can escalate up to whatever relevant committee or management chain or control that you have, just so you can start to predict what that's going to look like when the protected timelines kind of roll off and these loans may not be performing at that time. Rather than deal with that as one wave, I'd like the senior management and boards to be aware of what's going in that population.
Absolutely, Craig, I agree. And we have another note, I believe on the next slide, to get into the guidance as it relates to the classification of problem credits as TDRs, so that banks can be sure to assess things on the front end and make sure that they're meeting the appropriate accounting standards when reporting payment deferments, other modifications, forbearances for purposes of TDR. With that, Lee, I'll turn it over to you.
Yeah, let me go ahead and sort of walk down the rest of the slide. One thing that we need to keep in mind as we're talking about this is what exactly are the various steps that lenders should be thinking about taking in connection with dealing with credits that are in trouble right now. So, generally speaking, I think that there's what we're seeing is that unless we're talking about a credit that has some kind of historical problem and was teetering on the brink anyway, there's been a real reticence to exercise remedies and a desire to work with the borrowers to right size or restructure in order to see through what are undoubtedly difficult times for them and hope that things will normalize on the other side. So focusing on sort of broadly what restructuring is, there are a couple of things to consider when you're looking at that. And a restructuring really, I mean, it's really just either an amendment to the existing set of credit documents or a forbearance. We'll talk about the difference between those in just a minute. To permit the borrower to continue operating without having to exercise any remedies. So what are some things to think about in connection with that? You want to think about if there's a covenant in the loan documents that is obviously not satisfied and is not going to be satisfied for a period of time, and the bank can tolerate that the borrower operating outside of that covenant for a couple of months with the hope that either the covenant gets amended for the long term or the borrower comes back into compliance afterwards. That's a big part of what we're seeing and what we're doing. Also, exposure reductions. We will counsel our bank clients to take payments and apply them to principal to reduce exposure to a troubled credit anytime there's an opportunity to do that. Especially if you're not in default, you can't do this in a way that is arbitrary or in a way that could potentially harm the borrower. So you have to be careful. But reducing the principal balance to de-lever the credit is an important and very helpful thing to do if you can do it wherever you can. Credit enhancements and recapitalizations is sort of on the other side of that concept. Rather than reducing the exposure, you beef up the ability to collect or the collateral base, either by adding collateral to the credit or adding guarantors or perhaps taking additional funds in reserve. Anything that you can do to improve your collateral position should ultimately give additional flexibility on the back end. So it's another thing to consider. And then refinancing. Refinancing has been a fantastic opportunity over the last 2 to 3 years. To tell you, we've seen more troubled credits since about 2017 than we were seeing between, call it 2014 and 2017. I personally think just because there had been enough economic runway and new loans that we were starting to see sort of a normal default rate again. But because there was so much credit in the capital markets, or has been, and frankly still is, it was almost inevitable that borrowers that were in a troubled situation could find another lender that was higher priced and higher risk to take out the prior bank. We don't know what the state of affairs is going to be on the end of this crisis. So, while I think refinance was a great option, we'll have to see how good of an option it is going forward. But obviously, any opportunity that you have to monetize the asset for par or something close to par is usually preferable to the bank over taking an asset back into REO and then having to deal with it from there. One final point, which I think is an important distinction that banks need to keep in mind, banks and borrowers need to keep in mind really, is the difference between a forbearance and a modification agreement. The modification agreement says your loan agreement used to provide X and now it's going to provide Y. It doesn't do anything with an agreement other than potentially waive it. If you are modifying a loan, it's because either no default exists or a default exists and you are waiving that default. On the other hand, a forbearance agreement recognizes and acknowledges the existence of the default and keeps the borrower in default during the forbearance period, but promises not to exercise remedies arising from that default. So having credits in default is important to the banks from a regulatory perspective. It's important to the borrowers from a, they will always say, from a refinance and reporting perspective. But on the other hand, if you think that there is a likelihood of needing to exercise remedies, a forbearance is a very powerful tool because the default exists. You don't have to go through any additional notice and cure periods. You can accrue default interest. They're just a number of powerful sort of remedies tools that you get when you maintain a borrower in default under forbearance versus a modification. So those are all the discussions that we have with our bank clients when deciding which direction to go. And just know that those two terms are not fungible, and it's important to decide which one you're going to do. Unless there's anything to add on our side, could you advance to the next slide?
Lee, if you want me to jump in real quick on the interagency TDR relief, I will, because this segues nicely from your last note about the difference between forbearances and loan modification, is that the interagency statement on loan modification did speak specifically to certain types of payment deferments that did not automatically result in the loan being classified in a TDR. Specifically, it spoke to short-term modifications made in good faith in response to COVID-19 to borrowers who are current prior to any relief are not automatically classified as a TDR. The short-term modification, the statement gave an example that was anything that to some extent is insignificant and is less than 6 months, but it's very important to note that per the guidance, the borrower has to be current on payments, which they explain is no more than 30 days past due on their payments, in order for to some extent for the GAAP accounting rules to not apply to automatically classify that loan as a TDR. So again, that just encourages lenders to be proactive and go ahead and assess borrowers and assess loans. And if you're going to put a borrower on a deferment, you need to do so before it goes into default. Otherwise, you may have to reassess and run afoul some of the accounting standards on how you're reporting the credit. I think it's also important to note that, and the statement speaks to this a little, that not classifying the loan as a TDR also generally it's going to be understood that the borrower needed to be in somewhat of a healthy condition prior to the deferment. Taking a borrower that was already in trouble prior to COVID, utilizing potentially this guidance in the statement to put that borrower on a deferral to avoid TDR classification and charge-offs or reserves into the ALLL, it's probably it doesn't seem to be what the regulators are looking for in terms of the guidance. Again, these are for healthy borrowers that were not in default, but did want to mention that the manner in which you document the restructuring as a modification or forbearance, and if it's forbearance, it a lot of times, because it says the borrower's in default, that could play into the accounting standards and whether or not you have to classify the loan as a troubled debt restructure.
Yeah, and for some of our folks who may not be lenders who are dealing with TDR classifications, that's exactly what John was just mentioning, is having to classify certain restructurings as troubled debt restructurings, which changes the accounting treatment of it. And the nice thing is a lot of the bank regulators have given some relief to bank and credit union regulators to deal with those particular issues right now. so they don't have to reclassify them as troubled debt restructurings if it was specifically done in relation to COVID-19.
Yeah, and Brad, that reminded me one other important note I think in the interagency statement is that they also do explain that, you know, that loans put on the payment deferral do not have to be reported as past due because of the referral. So again, that you need to assess those early and put the deferral in place prior to the loan otherwise becoming past due.
Mm-hmm.
So additional, you know, in talking this over, there are some additional items to think about in connection with, you know, prosecuting a workout during COVID-19 just because business is not acting as usual. So some things to think about right now are the follows. And by the way, this is not an exhaustive list. We're constantly running into new sort of unforeseen questions daily, and we're dealing with them as they come up. So just know that, you know, if there's any time sensitivity on getting your workout done for any reason, it's better to start sooner than later because, you know, inevitably there have been logistical challenges that none of us are used to dealing with. So those include the following. Difficulty searching title. For the most part, the records rooms of county real estate records are open, but now and again we find them not open or not open to the public or simply not online or understaffed or working abbreviated hours. So if you've got real estate in your credit and part of your workout is adding that real estate to the collateral package or obtaining a date down endorsement on the title policy or allowing in a second lien money to recapitalize the borrower or something like that, just understand that there may be glitches with title, and you'll need to check the local county records room. Your attorney can do that for you to see if they're open, and if they are open, find out whether there are any challenges to getting title as expeditiously as possible and, you know, as timely as usual. Foreclosure and collateral liquidation risks, you know, with respect to real estate foreclosure, I imagine everybody's familiar with the fact that about half the states in the union are judicial foreclosure and the other half are non-judicial foreclosure states. With respect to judicial foreclosure states, kind of tough to file a lawsuit right now. You can file them in some states. In other states, they're not accepting new civil filings. Even if you can get it filed, there's a question about whether or not you can get it served. If you can get it served, there's a question of whether your local court that would hear the case is hearing non-essential, non-emergent civil cases. I don't know that a foreclosure would necessarily be considered an emergency. So there's going to be additional time that you're going to have to figure in for a judicial foreclosure. Now, non-judicial foreclosures obviously are less expensive and they move along at a much quicker clip, but those face their own sets of challenges at this time. For example, in Georgia, where I'm sitting, we have a non-judicial foreclosure process that provides that foreclosure day is the first Tuesday of every month, and you go out and you cry out your live auction on the courthouse steps between the hours of 10 and 4. Great. Well, what happens if you want to go have a public auction, but the public is afraid of attending your auction? What happens if the sheriffs, and I don't know if this is happening or not because we've only had 1 month worth of foreclosure day during the pandemic so far, but what happens if the sheriffs determine that a large gathering on the courthouse steps is a public health hazard and kicks everybody out and says no foreclosures today? There are things like that need to be taken into account. And again, they're pretty much unforeseeable at this point. So just be aware that public foreclosures are either judicial or non-judicial are things that are going to face some unforeseen challenges at this time that you need to think through on a case-by-case basis as they're getting set up. Same sort of issue with personal property foreclosure. You know, under the UCC, you can foreclose fairly quickly, and that is also a non-judicial process. But you have to hold a commercially reasonable sale. So, for example, if we're selling commercial real estate mezzanine paper, we will usually notice up that sale for our conference room in New York City at our office. Well, that's great, but nobody's going to Park Avenue in the middle of Midtown Manhattan right now to attend a mezzanine foreclosure sale. So is that commercially reasonable to hold a public auction in an office building in the middle of New York City during a pandemic? Probably not. So these are, again, just things that you got to think about in connection with the exercise of remedies that may sway, for better or for worse, the leverage in negotiation one way or the other. Thinking also about other sources of liquidity, of course, there's federal aid now where there wasn't before. PPP, EIDL, the Main Street Loan Facility. These are things that everybody's talking about now, and it seems like the guidance from Treasury is changing, almost daily on what these things can be used for and how they're being dispersed. So the best advice we can give you on that is to make sure that you stay in touch with your attorneys to have the latest information as to how this money can actually be used by the borrower and how it may be able to help recapitalize your credits. And then finally, collateral valuation. This is a tricky one because I think we all know that real estate is probably worth less money today than it was 2 months ago, but none of us really know how much it's worth. There's no sales comps. There's a couple months of rent that have been missed, but generally speaking, all the leases are still in effect. Nobody's been kicked out. So your sales approach and your income approach probably haven't changed. So on paper, the buildings are probably going to appraise for the same, but we just know damn well that they're not going to sell for the same amount. And I think the same thing's going to go for personal property if you were to get a personal property appraisal. With volumes down in businesses, inventory, to the extent it ever was worth anything, is probably now going to be worth less. And, receivables agings, you can look at an aging that has the meat of the receivables sitting in 30 to 60 day, in the 30 and 60 day columns. And that's great, except now you got to figure that the default rate's going to be higher because your account debtors may not have the money to pay where they used to. So again, things to consider now more than ever in connection with doing workouts during this crisis. And there's no blanket rules here. The best piece of advice we can give you is just to stay in touch with your law firms and try to think creatively for solutions around these problems as we're identifying them to construct the best solution for any given issue. Brad, you want to flip to the next slide?
And this is more of just kind of a reminder that, if you do start walking down the path of going into default, is making sure that you're giving proper notices. This is something that popped up during the last recession that we saw affect a number of our lenders. Plus, it's only, candidly fair to the borrower to give them specific reasons why the particular credit is in default, but also making sure you're protecting yourself, your institution, or your lending entity, which is, make sure you're keeping those reservations of rights, identify the specific defaults and the time so that there's not some debate later about whether or not there was in fact a default, whether cure periods had been provided, and then really communicate with the borrower what it is that is expected of the borrower, as well as the guarantors. One of the other issues that we saw pop up a lot during the last cycle is borrowers who were making partial payments, or you had different entities, such as guarantors who were trying to negotiate separately from the borrower and try to take positions adverse to each other. This goes back to what John was saying earlier about document, make sure you've got that complete loan file in place, which is really understand that there is a need to clearly document all the steps you take, what you're doing in response, and what the position is of the lender or the institution. But also understand that, when someone does default, oftentimes it is curable and that you can go through and continue to work with them. But it's important that just because you want to assist a borrower, you don't miss things such as legal deadlines and risk claims of waiver, or that it was a non-material breach that would later become unenforceable. If you do plan to treat it as a default, make sure that you're using it to set a default date and a default action. And then the last thing is understand that when you send those notices default, so many of us print it off of our core system and it's just a standard form document. Understand there are reputational risks with lenders and institutions right now that you need to be considering, which is if you just send a standard, quote, nastygram to a borrower, particularly if they're struggling to keep people employed, they're struggling through this crisis, it may come back to bite you as a lender. Would you like to see that as an exhibit in a potential future lawsuit? Or have them complaining or running to different groups and saying this is how the bank treats you. So understand, you've got to preserve those legal rights, but at the same time, there is a tone that you can set inside of that document.
Hey, Brad, to your point there about making sure all deadlines are adhered to, and you're documenting your default notice is compliant. I think it's reasonable to expect an increase in contested foreclosures and litigation, just given the scale of what's occurring. You will see more pushback from borrowers' attorneys on these issues going forward over the coming months and year.
Great point there, Craig. Yeah, and then as we consider how you go about making the decision of do you pull the trigger or do you not, there's a series of factors we put here for your reference. But, understand that this is really kind of a global discussion. And what I mean by that is oftentimes, what we saw in the last, financial crisis is you had a lender who had a personal relationship with a particular borrower. That lender oftentimes acted as an advocate for that borrower because of a long-standing relationship. Then it would sometimes go to a special assets group who is taking a very clinical, objective approach to it. But understand when you're dealing with special assets, it really is a team approach to this, which is, you've got to look at these credits globally and look at things such as, our workout plans, are they realistic? Is somebody doing a double check on those? When people say they're going to do pay downs, they're going to liquidate other types of collateral or substitute collateral. Do you have policies and procedures in place where you're going through the full analysis of that? And then, one of the things we saw catch a lot of our lenders during the last financial crisis is be aware of some of the non-monetary factors. We saw early on in the crisis people attempting to foreclose on, churches. We had a group who took a mortgage on a cemetery, which you should never do under any set of facts and circumstances. We had a group who had collateral was an $8 million fireboat, which is not very easy to sell on the secondary market. And so much of this was just moving forward because of a set of procedures that were in place that then it eventually gets over to the attorneys. And we see that there are significant issues with the credit and whether or not it actually is a wise decision. If you're trying to sell a cemetery on the secondary market, there's not a ton of value in that. And so everyone was somewhat shocked inside of this financial institution that there's not a market for those. And they had planned a great deal of their reserves as well as their strategy under the assumption that it would sell. But then similarly, make sure you're looking back on all those notes you put in your loan workout file to understand lender liability risks or creditor agreements, what have you. A few things that Craig mentioned yesterday that I think really are important is, don't underestimate also that as you work through a workout and you consider offering alternatives to these individuals, that you're overlooking fair lending concerns, particularly for small business loans. Modifications and workouts are potentially subject to fair lending. And so how you treat people, and if you're treating different groups disparately, protected classes disparately, then in those circumstances you potentially are exposing yourself to liability. But then the other side of that is understand that there has been efforts by the regulators to encourage, particularly in light of the COVID-19 crisis, lenders to obtain CRA credits, Community Reinvestment Act credits, for their help in restructuring loans in response to the pandemic. And so, understand there may be some additional options that are uniquely available to you right now if you start working down the path of trying to assist those borrowers as opposed to just exercising your remedies under the loan documents. And then, one of the things that we keep hammering on here, but it's important to drive home if you take one thing away, is document that decision. Here is why we chose to do what we did. So that way, if a regulator down the road or an auditor is going through and saying, well, why did you choose in this case to foreclose on the cemetery and you only got $50,000 for a cemetery that you had an $8 million credit loan against, you have the justification as we thought it was worth this. Here's how we went through the analysis, and here's how we documented it, even though the ultimate result may not have been what we were looking for.
And Brad, if I could mention one other thing on the prior slide, is it does mention, to consider your multiple creditor intercreditor agreements. Do be mindful of loans that have intercreditor agreements or participation agreements. Specifically with regard to participation agreements, they often contain, provisions, both pre-default issues and post-default issues, and different decisions and things that can be done, but often modifications and workout strategies require notice and potentially consent of the participating banks. So just be mindful to pull out those participation agreements or other creditor agreements and follow your notice procedures, follow procedures related to if majority or all of participants are needed to take a certain course of action, that you're getting that, because otherwise you could expose yourself to some breach of contract claims.
Good point. On the next slide, for working it out, I think I'm just going to try to move it a little quicker, noting the time. I want to make sure we have some time for Q&A. On this slide, we wanted to point out for operational processes, you should be clearly defining what steps you're willing to take and working with your credit, risk, and servicing department all at the same time to ensure that you're all on the same page. Regulators will be looking to see how you handle default servicing over the coming months and year and a half. And as we saw in the last downturn, processes that were working when only a small percentage of your portfolio was in default may not be working when default rates rise dramatically. So you should be contemplating the bullet points listed below or right here, and these questions, and addressing within the procedures that we were referencing earlier. For example, will it include modifications, forbearances? How are you going to approach TDRs? You shouldn't be making these decisions in real time. You should have a clear approach to how this is occurring. What are the ongoing obligations? How are you going to monitor them? Is the workout plan reduced to written documents reviewed by legal counsel? To our point earlier, we can expect increased litigation and contested foreclosures here, so you're going to want to take care and kind of increase the scrutiny around these processes. Also, to Brad's point earlier, the reputational risks, you're going to want to start to see, like, what do your controls look like for reputational risk? Are any possible reputational risks being escalated up to legal, escalated to risk or compliance? A lot of the time, especially in the last downturn, you have departments that are charged with, make the asset a performing asset or foreclose. They have direction not to extend the lifetime, so they're very focused on either getting the foreclosure completed or getting the workout completed. Once they switch to that foreclosure mentality, you want to make sure that they're aware, like they can take, breathers to escalate reputational risk, and that those business units won't be criticized or penalized for escalating issues and possibly adding a little bit to the timeline if it avoids, a front page story for your bank. Next slide, Brad. The workout toolkit. We want to stay here, give you kind of high-level overview, what you should be thinking about within each of these silos. The tools here echo what Lee was walking us through earlier. They showcase high-level questions, and you should always be thinking that the goal is not to have the loan perform in the short term, but rather triage the situation for a sustainable positive result. We would rather have a portfolio that we knew the credit quality of and were confident in the performance than kind of living in this in between where we were constantly working out a large percentage of the portfolio. So if it's not working, I guess you should be asking your questions here. Are you prolonging the inevitable, or are you actually improving the credit quality of the portfolio? I think 18, Lee, you were going to address. The next slide.
Yeah. So in starting your negotiations with a borrower over a workout, when you have a potentially contested scenario, you have to be attuned to the communications, really hypersensitive to the communications that the bank officers are going to have with the borrower. The danger here is that oftentimes a lot is said back and forth, and in particular, these days in email, a lot is said back and forth in writing on an informal basis that could be construed or proven by one party or the other to either be an enforceable and binding contract where you didn't mean it to be, or at the very least induce reasonable and justifiable reliance that could put you in an estoppel situation and cause damages. So how do you mitigate that risk so that you can have open and honest discussions with the borrower to come to the best possible solution? And the best way that we know how to do that is to go ahead and sign up a pre-negotiations letter. A pre-negotiations letter is really just an agreement at the very beginning of workout discussions that says, hey, everybody understands that the ground rules of the next foreseeable future of discussions are going to be that the parties are not going to have an enforceable agreement and that nobody's going to be entitled to rely on anything until the parties have one written document that encompasses the entirety of the terms of the subject matter that is duly executed by all necessary parties. Period. Hard stop. That way, if somebody comes, if things don't work out in the workout, and your borrower comes back to you 6 weeks in and says, I don't care that you won't sign this document. This is what you told me a month ago, and this is our deal. You can hold the pre-negotiations letter up and say, no, we don't have a signed document, and that's what you agreed at the beginning. And I'll tell you that this has saved me on more than one occasion. One time in particular, in a piece of very highly contested federal litigation, we had finally backed the borrower into a corner. We were about to monetize our collateral. We were going to the judge, who had become finally cooperative with our position. And the borrower piped up and said, it dug an email out of the probably hundreds of emails over the course of the workout and said, you promised you wouldn't do this. Here's the email. And we were so thankful that we had signed up a pre-negotiation agreement at the beginning. So we sent him the pre-negotiation agreement. We said, no, you agreed that there would be no agreement until something was signed. And that entirely shut down that line of argument. And we went on and did what we needed to do before the judge. So, again, it's a very practical, very important thing to have. So quickly, what's in them? Every law firm has their own form, but generally the pre-negotiation agreement says, this is what the loan document looks like. If you have defaults, the borrower will, you can try to get the borrower to admit defaults if you can. Primarily, it's the party's obligation to negotiate in good faith. The fact that negotiations are non-binding, the fact that they're only enforceable upon a written agreement signed by all parties, the fact that everybody reserves rights, both the bank and the borrower. It's good practice to include that settlement discussions are subject to Rule 408. That is a federal rule of evidence that has been adopted in every state in which I've ever practiced, that says that settlement negotiations are not admissible in evidence. So as much as that is, annoying, for lack of a better term, for the banks, it's a good thing, because you can say to the borrowers, on these occasions, look, maybe I acknowledge that the way I comported myself wasn't perfect over the course of this credit, but we still want to negotiate. And that is something that's not admissible, and you won't have actually admitted anything for the purposes of lawsuit. And those kinds of statements can really build goodwill and help advance negotiations forward. Releases of pre-existing claims, something that is always in a forbearance agreement, oftentimes in a modification agreement, sometimes in a pre-negotiation letter. Whether or not you can get a release of pre-existing claims is going to turn entirely on the leverage among the parties that is brought to the negotiation. And make sure that the people who are signing are authorized on behalf of all the corporate signers, and make sure that you get the borrower and the guarantors to sign, because it doesn't do you a whole lot of good to not have an agreement with the borrower if now your guarantors can argue that can argue binding agreement or promissory estoppel, and they wind up being a large part of the credit support that you're looking to. So these are important tools, and they sort of are the last thing that people think about when they start negotiating, but they really need to be brought up as the first thing, and your legal counsel needs to be on the forefront of reminding you that it's important to do these. So next slide, Brad.
During the last downturn, we saw themes that drove issues while loans went through the workout process. They included FTE allocation, operational resources, but we wanted to provide some bullet points that you should be considering as you shift resources and shift your attention over to default servicing. And you're going to want to contemplate, are you throwing good money after bad? Building off what we've discussed so far, the procedures, the alternatives, what you should be considering as you're looking at defaults, you want to make sure that the resources that you're allocating, the time, the money, outside counsel, any consultants, that you're contemplating, is this going to result in a benefit to the portfolio? If not, you have to kind of contemplate the other side. Should we just rip the Band-Aid off and kind of go towards the liquidation phases? I think the next slide, we're back to you, Lee.
And also, I'll just mention while we've got a moment that if anyone has any questions, feel free. I mean, we've run up to our hour, and want to make sure that if anyone has any questions, you can answer. You can pose those. You can just simply pose those here inside of the GoToWebinar application. We'll be happy to address those. We'll continue here for a few minutes just to cover these last couple slides, but if you do have questions that come up, feel free to go ahead and post those in, and we'll try to address those specifically. And so, Lee, back to you.
Thanks. Here I've been talking for the last 30 seconds on mute. So enforcing your rights. So things to think about that will happen if your workout is not successful. You negotiate with a borrower for 3 or 4 weeks. You're just not getting anywhere. You're not able to voluntarily bridge the gap. You decide that it's time to start enforcing the rights under the loan documents. Well, what can you do? Well, the first thing that everybody thinks about is foreclosure. Foreclosing your security interests, like we talked about earlier, takes different shapes and forms depending on whether it's real estate or personal property collateral, and then whether you're in a judicial or a non-judicial state for the purposes of foreclosure. That is the processes are drastically different depending on all of those factors. So you just need to be in touch with your legal counsel to talk about exactly what they look like. Tell you in Georgia, you can foreclose a piece of real estate depending on where you hit it in the month and with the relevant advertising deadlines of the applicable newspaper. You can foreclose in about 35 to 40 days. The flip side of that is a place like Louisiana, where there is heavy involvement from potentially active sheriff's offices, where your non-judicial foreclosure could involve some level of lawsuit and could take 3 or 4 months. On the judicial side, same spread. A voluntary foreclosure in the state of Illinois could take just a couple months, even though it's judicial. And by voluntary, I think what I really mean is consensual. Versus Florida and New York, those could take a year or more. Depending on the court system and how litigious your borrower is. Possession and sale of the collateral, again, if you've got personal property collateral, so if we're not talking about real estate, if we're just talking about personality, the UCC provides after default, or even without a default if your agreements provide for it, that you can demand that your borrower assemble and make available your collateral for you so that you can go ahead and foreclose it. Now, in the years I've been doing this, I've never had a borrower actually comply with that demand. So as long as you can go out without breaching the peace, you can go round up your own collateral and make it available for foreclosure. And then go ahead and sell it. Sale of personal property under the UCC, again, just needs to be commercially reasonable. So assuming in this environment that you can have a public auction or figure out a way to do an online auction, your commercially reasonable sale and auction process, we usually say can take, 45 days, 30 to 45 days at the, sort of at the fastest, and we can do them in about 60. Receivership is also usually very attractive if you can get it. Receiverships are tough if your borrower is going to fight you, but it's a judicial remedy in which a fiduciary is appointed by the court, answerable to the court, and runs the company for the benefit of the court and the parties. You have to be careful as the bank in seeking these because they can be expensive and they can come back to bite you if they're not well thought out on the front end. So you make sure that you recommend a receiver that you trust. You pick a judicial forum that's going to be, quick and try to make it the least costly as possible, and try to have some kind of end date or end deadline on the receivership so that you know it's not going to carry on forever and just continue to run up fees for the bank. And then finally, involuntary bankruptcy. This is not something that is really available to banks as secured creditors, but if you are an unsecured creditor and you can find 2 other unsecured creditors for a total of 3, for a person with over $12,000 of debts or companies with over $12,000, which is basically any, you can file an involuntary bankruptcy petition to push a company into bankruptcy. Now, this from a bank perspective is usually the concern that you've got, that a company that's not paying a borrower that's not paying its debts as they come due is going to be sued for involuntary bankruptcy by its trade creditors. So that is just something to keep in mind. What you'll usually want to do there, if the borrower is not going to fight the involuntary, is to step in and work with the borrower to get the involuntary converted to a voluntary case and support the borrower with benchmarks and end dates so that you have control over the case. Unless, of course, you don't think that the credit belongs in bankruptcy, and then you can move for stay relief or move to dismiss the case or what have you, depending on what the facts are, and we'll talk about that in a minute. And then as far as the consequences, again, exercising remedies is not a panacea. Once you have your collateral, now you have to sell it. So there's cost of management, there's cost of carry, there's cost of sale. You've got to make sure that you can market. You've got to make sure that you're acting in a way that is maximizing your ability to collect from your guarantors. So all these things are things to take into consideration. I will say, with respect to the guarantor deficiency, one thing to be particularly attuned to in the real estate space is that most states have most non-judicial foreclosure states have some kind of anti-deficiency statute that requires certain things of the lender in foreclosure so that a deficiency can be preserved. For example, in Georgia, after you foreclose, before you can sue a guarantor for a deficiency. So what I mean by that is if you got a $1 million loan and you sell your collateral for $600,000, now you have a $400,000 deficiency. Before you can sue your guarantors for that $400,000 deficiency, you've got to go get an order from the Superior Court in the county in which the foreclosure occurred, confirming the sale, the foreclosure sale. And that means that the sale was prosecuted in accordance with the foreclosure laws and that it brought in fair market value. And during the Great Recession, what constituted fair market value became a battle of the experts. The bank would hire an appraiser, the borrower would hire an appraiser, or the guarantors would hire an appraiser, and you would have, sometimes 5-6 hours of evidentiary expert testimony on the value of property before a Superior Court judge who, him or herself, was not an expert appraiser. So it became a very difficult set of circumstances. Now, the law in Georgia has changed somewhat to protect against that kind of thing from happening again, because a lot of guarantors were able to get out of their the guarantees that way. But but still, just things to think about depending on your jurisdiction. It's important to think about what you might be able to recover from your guarantors and structure your exercise of remedies in a way to maximize that. So, Brad, next slide.
And so this
John,
is really,
go ahead, Brad.
Yeah, and this is really just kind of thinking globally about enforcement. When you go through your process of thinking about kind of enforcement, make sure you're thinking about it globally. It's not just as simple as foreclose or file an action. Make sure you're thinking realistically about, what's the right remedy? How do you get highest and best? Special asset groups are very good about doing that. But at the same time, you need to make sure the your entire institution's aligned so that you have a clear picture, and then make sure you're documenting in the loan file and the workout file so that you can see how you address that particular those concerns about how you're going to enforce these. We'll turn back briefly to kind of some questions regarding collateral management. There's some slides that we'll be sending to you after the presentation on bankruptcy concerns that we want to include for you as well. Feel free to take a look at those. But one of the things we've seen a lot come up, and Craig, you may be able to talk about this, but understand that once you have collateral or you're working with borrowers who are potentially on the verge of default, that you really need to be attuned to other potential risks associated with that collateral, that someone is monitoring for legal notices coming in. We saw this hit a lot of the banks during the last downturn, where they were getting legal notices of tax sales or HOA liens and foreclosure actions by secondary lien holders that were not being responded to appropriately. Same thing with insurance, same thing with super priority liens, like those sometimes that pop up for water, sewer, and fire districts. And then make sure that you're not running past redemption deadlines. I mean, there's legends of various institutions sending lawyers with checks to sales to try to redeem properties by deadlines because they were missed when you have the spike. And so when you have a default scenario for the borrower, it's unlikely that they're just defaulting to your institution or organization, but instead there could be a lot of other things that are falling through the cracks as well.
Those also get way more, the liability rises very quickly with those as you move past default into REO status. You can start to see some of the bank executives get hit with arrest warrants depending on what they've missed. If the county is looking to make a high-profile collection effort or is just frustrated with your bank in particular by missing various liens that aren't a priority in your core servicing systems, it's often missed, but it's a very high liability for your default servicing groups.
Yeah, this next slide we'll just briefly touch on, but it provides kind of a summary of all the different lender liability claims that we saw during the last downturn. Most of these, and I think John made a great point as all of us were preparing yesterday, is about half of these can be knocked out by being careful with communications, and the other half can be knocked out by being careful with your loan workout file. But the baseline rule of thumb is just, anytime you're training everyone from frontline bankers to special asset staff to collectors to customer service, make sure that you're driving home the point that anything they say or send, using the nasty email monster, could potentially be an exhibit in a lawsuit. Even internal emails can sometimes be discovered, and if you're sending back statements about, what a crummy credit this was, and, the collateral's worth nothing, and how can you even imagine that we accepted this rotten appraisal back then? Those are potentially exhibits in a lawsuit. So anytime you're talking about a particular credit, anytime you're talking about a potential workout, make sure you realize that at some point this could be presented in front of a court or a jury on a big enlargement, and really be intentional when you're thinking about what it is you're saying. Similarly, this isn't emotional, this isn't personal. We saw that sometimes with commercial lenders where they had a big credit they were trying to work out. They felt a personal connection with the borrower, and they felt, and it got personal as opposed to unemotional and professional. So, really keep that professional wall up, and you can avoid a lot of this. The last thing that we'll kind of hit on in this that we particularly want to point out right now is make sure you're not crossing the line from the relationship of a debtor and creditor and providing fiduciary advice. If you are advising borrowers on who to pay, how to pay, advising them on taking out other loans, giving them legal advice about who can and can't pay, all of that potentially is creating risks to your institution. And so, though it is oftentimes tempting to help a borrower in that way, and make sure we're not crossing that line and creating additional potential risks for our institutions or for your company by crossing that line from an arm's length transaction to actually engaging in what would be fiduciary obligations. At the end of the day, just, remember it's an issue of training, and right now you should be prepping for this, particularly given how disjointed people are operating right now, where you might have a lender who's working from home and he or she is not communicating with special assets in a different location. It's important now more than ever to go ahead and prep for this so that you don't run into these little speed bumps as you work your way through. And then finally, John, you want to talk just briefly about OREO management before we close this out?
Sure. And you hit on a few of these things earlier on, and it's just a couple of notes with some things to keep in mind as it relates to your other real estate owned as you take it in. Is remember that in many states and with your national banks, there are statutory holding periods that are in place where the regulators are going to want to see you effectively taking in and selling OREO at a very timely basis. I've seen enforcement actions related to those holding periods before. So if you happen to hold OREO beyond the statutory holding periods, make sure you get your notices out and you get the approval from your regulators that you need. But again, the goal is to efficiently take in and sell OREO as quickly as possible. Be mindful of your appraisals and the appraisal management, and that you keep it updated. That can affect the accounting standards and the value at which you have the asset listed on your books. So be sure to look at your appraisal policies and procedures for OREO and make sure that you feel good about those. Also, with regard to environmental issues, this goes back to doing an assessment of the file and of the collateral prior to taking action. If there are environmental issues associated with a property, it's good to discover those prior to owning it and taking it into the lender's name for purposes of title. So always be wary of environmental issues for certain types of higher risk properties. And then finally, I would recommend having a process in place for the brokers that you might hire to sell your OREO and then sales contract management. I would encourage the bank having a form OREO sales contract that is very limited as it relates to representations and warranties, just because managing different forms of sales contracts and the terms related to each sale can be challenging. It's better, again, to stick with a form that the bank is accustomed with and understands and knows the business terms to try to avoid any contract liability. And again, with that, Brad, I know we've run up on time, so I will stop there.
Well, thank you, everybody, for joining us as well as hanging on with us as we ran a little bit long today. As with all of these presentations, this will be posted online. It's available on YouTube as well through the firm's website for your reference in the future. We'll also be posting the slides to the firm's website, and each of you who participated today will be getting an email with a copy of the slides that we went through. Most importantly, I want to thank our presenters and thank each of you who participated today. We appreciate what you're doing to work with these borrowers, respond to this crisis. And, we recognize that you are in the trenches dealing with these issues, and we're glad to be able to support you. With that, thanks, everybody. We'll be signing off and appreciate all the participation.
Thank you.